hour is 11:21. I almost made my 5-minute break timing. This is the time and place set for a workshop of the Nevada Taxicab Authority Board on proposed regulations pursuant to 233B. It's been duly noticed, and we have before us a number of proposed regulation changes, which I will outline in a moment. But the first item is that in connection with the requirements of 233B, a small business impact questionnaire must be completed, and they are available at the back table. And we would ask the industry to fill them out and provide any feedback that will be then combined into a single report and published, as well as what is taken today informationally, I believe, and any subsequent proceedings if there are any. Well, there will be a. So we haven't done one of these for a while. For those of you who have not done a rulemaking in recent time period, and our deputy AG will keep me on task here, the workshop process is not very new, but somewhat new to 233B. It is required that we do so, take public comment on the proposals that have been prepared, other proposals that may be presented today, and discuss them, take comment on them. We are not in a position to adopt today. That would be at a subsequent proceeding after these have gone to LCD and been blessed for any additional consideration by the board. Ms. Webb will keep me straight here. We have a packet of changes. That's the big packet. And it looks like we got a proposed change on Monday from Lucky that is in our packet. Has that been made available to others?
I think you emailed it out.
What's that?
On the pages that doesn't very much.
Mine was only in regards to the security deposit, NAC 706559.
Is that something that is out for people to see, or do we need to take
It was
comments?
discussed at the previous workshop, but just a couple verbiage is missing, what we discussed.
Okay.
I emailed
Okay,
along.
so we'll take comment from you to fill in that blank. And then there is another document at the back, which is 2 pages, and I am the guilty party. These are some suggestions I want to discuss. What I plan to do is allow Ms. Webb to go through the large packet with us and go through it in its entirety. And I'm doing it that because we're tinkering around the edges. It's not like there's big provisions. So my plan was to have her go through the whole packet, and then we'll take comment on that. Then Desiree will take your comment, and then we'll conclude with I'll review what I'm suggesting on the 4 changes. Any questions, comments, or concerns about that process? Yes, Administrator.
I just have one comment. Because we are recording, I just would like to have everybody identify themselves.
who they are. Okay. Do I need to identify who I was?
When they speak, yes.
So the record should reflect that Member Decker, Member Gray, paragraph, who will have to leave shortly, are here, and then the research chair, but we do not need a quorum for the purposes of conducting a workshop. So, great. Ms. Webb, would you take us through the work that's been done in the informal conversations?
Sure, if you don't mind, Chair, Chair and I are going to share this duty.
Oh, you're going to share this?
Yeah.
Okay, great.
I get the
So
dumb
is this-
ones and she gets
You
the smart ones.
get the hard ones, and you get, oh, very good.
Todd Park, for the record, Taxi Cab Authority Administrator. Starting off 706-450, number 4, the definition of driver. We're changing, driver means a person who is employed by a certificate holder to operate a taxi cab or an independent contractor leasing a taxi cab who will strike the word to, operates a taxi cab and includes a certificate holder when the certificate holder operates a taxi cab, and then we'll strike the term does not include an independent contractor. So that's the changes for that one.
And this conforms to practice as it exists today.
Correct.
GD Decker, for the record, I just want to say this resolves the significant problem we had last year.
Right.
Okay.
And also the source of an opinion that didn't go forward, so.
And under 706-450, number 6, lease medallion means the metal plate, digital or other means will be added, issued by the authority pursuant to NAC 706-5565, which is, and strike out the words affixed to and replace it with maintained in a taxi cab, authorizing it to be operated by the independent contractor within the jurisdiction of the authority. The reason I wanted to do this is to look forward to potentially having digital medallions at some point. We don't have them right now, but I thought now is a good time to change that language. Number 7, medallion means the metal plate, digital or other medium will be added, issued by the authority, which is strike affixed to, and again, add words maintained in a taxi cab, authorizing it to be operated by a driver within the jurisdiction of the authority. And that's all for page 1.
Can I just ask a question?
Yes.
So today it's a metal plate.
Today it's metal plate.
So is it going to come off the back of the cab and be inside the cab now?
Not right now. No. The reason for this verbiage is to prepare for a digital medallion somewhere down there.
Yeah. And so my only question is, does it need to say maintained in or on or in? I'm just asking. I'm not trying to make it more complex, but
On a taxi cab.
I see
right.
what you mean.
It should be on.
yeah, so on or in, maintained in or on, yeah. A metal plate on, digital in, or just on, you get what I'm saying?
Yes, I do.
Yeah, because then there would be a non-compliance if it was
Right.
not in the cab.
Okay, thank you. Page 2, NAC 706-465, number 2, a non-refundable fee of $400 instead of $200, so strike out the 2 and add a 4. And that's the only change for page number 2.
Does that 400 capture your actual cost?
I would assume it does. For the paper and stuff, it just.
Page number 3, NAC 706-476. We will, I'm sorry, 706-474, number 2. Add upon request by the administrator, certificate holders shall furnish to the administrator a current list of supervisor or responsible person in their employee. Strike out which includes a schedule indicating that when they are available. The persons, and then strike out on this list, must be authorized to act for the certificate holder in dealing with the authority. The reason I wanted to get rid of this is it's just redundant. We get that information from them anyway. There was no reason for us to have that in an act.
Do you need to affix a time period which in they will respond to you?
I don't think so.
Okay.
JD Decker, for the record, because it's saying upon request, the time period is whenever they want it, essentially.
No, how fast they have to provide it.
Oh,
In
gotcha.
other words, you make the request and they give it to you 2 months later, and now the purpose is, I'm just asking.
Yeah.
I,
There wasn't one in there.
There was not one in there.
moving on
Just
to,
because I'm asking questions doesn't mean there's a problem. I'm just asking you.
no, that's good. I like the dialogue. NAC 706-476, we're changing we're going to strike 2 and go to 5 working days after receiving the complaint. This is going to be easier for the industry, especially over weekends and holidays, to be able to get the information to us. NAC 706-477, we will strike the last sentence within 5 working days after the end of each month. Each certificate holder shall provide the authority with a list of all drivers whose employment was terminated during the month. That, on your copies, probably does not strike out that whole last section. In meeting yesterday with my staff, we felt that whole last sentence needed to come out.
So the whole sentence beginning within 5
Within 5, yes, beginning with
to
that.
the end of month would be stricken.
Correct.
Okay.
Moving to page number 4, 706-481. On this one, we would strike all of number 3. Do you need me to read
No,
everything that's?
no. So section 3 would be stricken as shown on the draft.
Okay.
We're not doing that today, right?
No.
Yeah. Have we ever done it? We did it one time when it was something important to a particular legislator or something? Okay.
When we had
Okay.
a program.
Yeah, there's no program.
That's what I thought. Okay.
NAC 706-483. This is really just a definition change. The authority is the board, the administrator is me. So we will remove the word authority and make it administrator.
So you're not going to use your inspectors anymore? You're going out in the field?
No.
You might want to say the administrator or its or it.
I
His or her.
think you may want to retain or
Yeah.
designee, and
Okay.
I
It
agree
does
with-
say that in the definition.
Oh, it does? Oh,
The
the definition of administrator has,
does
okay,
say
that's fine,
designee.
that's fine. And the other reason is sometimes, at least when Member Decker was acting, we were letting Metro give us,
Yeah.
we're letting Metro tell us.
Yeah.
So, okay. Great, that solves my problem.
Member Decker,
Sorry.
are you okay with that?
I am. I would recommend that you add in your own discretion and say the cab may be inspected by the administrator. But if you want them all to be, if you want it to be in NAC that you have to, that's more restrictive for you than being able to use your discretion and saying, and the cab may be inspected by the administrator. So I would just think about how you want to play that and how you want future administrators.
Must goes to may.
Right.
Cab may be inspected.
Yeah, because whenever taxi cab is involved in a crash, the authority
Yeah, right.
must be notified, and the cab may be inspected by the administrator, gives you the discretion to decide if that's something that's important to you.
I think your change with inserting may is the easier for LCD. But I get your point. I don't need to go see every fender bender.
Right. And now you have to.
Yeah,
Yeah.
Right. Page number 5. NAC 706-486. Under B on page 5, display in bold block letters not less than, and strike out 6 and move to 4 inches in height. The unit number of each taxi cab on the, and then sides of both front fenders and on the left of the rear trunk lid, striking out of the, and then trunk lid, and then striking out most of C with the exception of unit number, and I think we would have to move unit number probably up to B. I felt it necessary to keep the unit number on the cab, but I don't see any reason to keep the telephone number
So the
on the cab.
unit number is just going to be on the left rear of the taxi cab, not on the right?
No, it'll be on the fenders. And to me, the reason I want to keep it on the fenders is really for enforcement purposes. If one of our guys are out looking for cabs, it's going to be easier to identify them if they have the numbers on both sides and on the rear.
But you're striking both front fenders. You want it on the rear?
No, I want to keep the front fenders. When we originally did this, we talked about striking the front fenders, but
My copy says that the front fenders are stricken.
Right, but this morning we changed it, or
Oh,
yesterday afternoon.
okay, okay.
So where is it, the rear or the front or?
Yeah, sorry about that.
the front and the rear.
So it's
Okay.
going to stay the same, it just went from 6 to 4.
Correct.
Oh, I got you. Okay.
And it's not on the trunk.
And it's no longer on the trunk lid.
And no phone number.
Okay, so this stays.
But sub B, the copy we have on sub B does not accurately reflect what you've decided to go with. Can you just read it?
what
how
you're
it's
actually
supposed to be?
doing now.
Display in bold block letters not less than 4 inches in height, the unit number of each taxi cab on the sides of both front fenders and on the rear of the taxi cab in plain view in a color contrasting with the color of the taxi cab.
Okay.
Left,
So
left,
the left is stricken.
rear.
Yeah, location is no longer there. It's just on the fender.
You didn't say that.
Display in bold block letters not less than 4 inches in height, the unit number of each taxi cab on the sides of both front fenders
Okay.
and on the left rear of the taxi cab in plain view in a color contrasting with the color of the taxi cab.
So you're gonna have it on both front fenders and just the left rear. That's how you want it to.
Yes.
Okay.
Which will become.
Can I ask about the telephone number going away? This is a consumer question.
Sure. And I thought about this. The telephone number is inside the cab in several different places. I was just thinking of myself when I walk up to a cab, do I look and I look at the telephone number? No, I don't.
Yesterday in the queue, which was very long, having read these on the plane coming down, I looked at all the telephone numbers.
You did.
But I didn't write any of them down. Okay.
At this spot, yeah. At this spot, I want to bring up another marking that's on the taxi cabs that I want to see go away. It's the helicopter numbers on the top of the cab. This was done by a board ruling in 1997. We can't even find that board ruling any longer. I don't see any necessary reason to keep those. And I know it would be a cost savings to the industry to get rid of the helicopter numbers. And so even though it's not in the NAC, I just wanted to bring it to your attention.
So we did talk about that at a couple of previous
think with the
board
last
meetings.
administrator,
And the same statement was made at the time when I said, well, where does it say that in the law? And they said, we can't find it anywhere. So I understand what you're saying. And my understanding is Metro doesn't care.
And honestly, I don't care.
Okay.
And apparently the industry is not required to do it.
Right. Yeah, there is no law saying they have to do it anyway. So.
Feel free to put whatever you want up there.
Or nothing.
Or nothing. Right.
That was one
Wonderful.
of two orders we were going to
Yes.
ask for you to consider
Yeah.
repealing.
All right.
So
Under the section just below F, we need to change the phone number, so strike out 486-6532 and add 668-4000. That's our current telephone number at Taxi Cab Authority.
Okay.
Do you want to go to the next one?
NAC 706-487. Lona Webb for the record. Strike out the entirety of paragraph 1C. With respect to paragraph 2B, strike out 3 color copies and change it to 1 color copy of photographs, photograph. So strike out 3, add 1, change copies to copy. And get rid of the S on photographs. Remove 2C in its entirety. Paragraph 4. The administrator may approve an application file pursuant to this section, subject to, and then strike out. I'll go back to that. Strike out everything through 4D after that. And the administrator just pointed out that on paragraph 2, we are striking paragraph D in its entirety.
The rest?
No, just D, a copy of any written
Yeah,
contract.
D is in dog is going away.
Yes.
The color scheme, the 4C, that's not an issue? Not an issue to industry?
Which one again?
Someone
Then you have
copies
to-
your design and makes their cabs look
Yeah,
just like
we
yours.
did have
or-
an issue with that one, but Kimberly said we would deal with it afterwards. or-
Okay. Okay, okay.
So that was 4A through D. Well, yeah, A through D strict. But then
Before you go to
paragraph-
4, I have a question on 3, which there's no
Okay.
change in there. Just showing a personal pension. Why wouldn't we change denied to approved, deemed approved? If you don't do anything, why should it be a denial? Why shouldn't it be an approval?
It's a good question. I don't know why it's in there like that.
Well, I understand what you're saying, and I like that idea, but it puts a 30-day window on you. And if you haven't looked at it because of whatever your volume and workload is, the danger is something slips by that you didn't look at because you've got a time issue.
Just perhaps for in between administrators, it's happened before. I could definitely see that happening.
Okay.
A delay, like that.
Because they can re-look at it and approve it once they get to it, but once it's approved, it's now a whole different thing to do.
Yeah, no, I get that. But a great many agencies are going to, if we don't do something in 30 days, then it's approved and it's our fault. Okay, that's fine. Understood.
So 706, 487, continuing with paragraph 6, out A and B. And strike out paragraph 7.
I thought that it's 4, A, B, C, and D are gone.
Yes.
And that E should be gone too. Subject to the temporary modification of the taxi cab does not create risk, right?
Yes.
So the parenthetical E should be stricken and capital T should be lowercase.
I see what you mean. Yes.
What is a temporary modification? Exactly.
These are the wrap, advertising wrap.
Temporary in the sense that it's not permanently painted. It's
Yeah,
not
right.
just like you're only gonna do it for a
6
week.
months or something, you take it off.
I got it, okay. I mean, well,
But this allows you to have it for longer than that if it's
Yeah.
Yes.
and
something that's going
they
on,
usually-
like
Sometimes
a,
they do, they're
Right.
but yeah. it's-
okay.
706-489. Displayed on the left.
before we go to 489, aren't we striking 6, A and B too?
Yes, I thought I already said that though. 6A and B is stricken.
So 4, A, B, C, and D are gone. E needs to be stricken and the capital T should be a lowercase t, and that same correction needs to be made in 6. The C should be stricken, the capital T should be, you're getting rid of all of the subsections, right? Just probably being more technical than I need to be.
Well,
but
I just-
This is what I do for a living.
That is, I just thought LCD would destroy it anyway, and I
Okay.
wasn't helping them that much, but yeah, that is perfect. So,
So again, on 6, I've got a little bit of it. I mean, is it, do you want to just go through them and then talk about them, or are we talking about them as?
Yeah, I think we are, and then we'll take
Okay.
industry comment on top.
Okay, I think I probably have an issue with striking 4C and D, and 6A and B.
There's no A and B anymore.
I think that
LCD's gonna be real.
my guess is industry is going to care about copycats, and that the graphics are sufficiently distinct from their brand. I also think that you should be able to say, hey, that, especially when we're talking about wraps, is a temporary modification. When they get faded and unreadable and, look horrible, I think we should be able to go in and go, hey, otherwise you're going to have, who knows what you get. You have cabs that are, the wraps faded, can't read the numbers or that kind of stuff. I don't know why you'd want to remove your ability to say, hey, that, you need to just do something about that, but.
So that's for B and C,
4C and D,
for C and D.
and 6A and B.
so 706-489. We are striking the word fender, the first paragraph, so displayed on the left rear of the cab and adding or as otherwise available in a digital format. 706-492. Paragraph 4. Striking carburetor and changing that to engine. Paragraph 8, adding another sentence. If there exists a manufacturer sticker that obstructs the view, the administrator may make the determination of vision impairment or not. Paragraph 11, D, strike that. Seven oh six 495. Two-way communication rather than two-way radios.
Sorry. On 11D, you could say windows that have not been tinted more than the legally allowed limit in Nevada or in the jurisdiction.
And that was my intent, is there's state law that
That already takes care of
already
it.
takes
Okay,
care of it,
gotcha.
so that's why it's just striking the whole thing.
Perfect.
We don't need to say it, it's already law.
Right.
So 495 again, two-way communication rather than two-way radios. And paragraph 1, two-way communication rather than radio.
So you're now gonna say using your cell phone's perfectly fine? Is that the intent?
As long as they're not breaking the law.
Okay.
Well, most of those communicate.
Through the meter?
Right.
But
And that was the
your,
intent.
the wording allows you to say, hey, I'm just gonna use my cell phone. That's gonna be the,
As long as they're not breaking the law.
okay.
I mean, there's cell phone laws on the
Right.
books
They're
that,
doing it now.
They are. Well, they have radios now, don't they?
Yeah, there's a radio, but they're
they're using. their
frequently
cell phones.
talking on the phone
With
with the
dispatch?
dispatcher. yeah.
Oh, there? Oh. Okay.
NAC 706-497, 3C, remove, strike out or and strike out D. Remove
Lease,
or lease, yes. And remove paragraph 4 in its entirety.
so you need to put an or on B if you're taking the
Yes.
or out of C.
501, paragraph 2. Strike the last sentence. Paragraph 3. Each certificate holder shall equip its taxi cabs with one or more amber lights on top of the taxi cab, which are plainly visible, adding during the daylight from all angles at a distance of 100 feet. And striking paragraph 4 in its entirety. .504, paragraph 1, strike the end of the sentence, striking at both the taxi meter and transmission. And strike paragraph 2 in its entirety.
Can is it on paragraph 2, is it that we just don't do seals or this is,
I'm gonna phone a friend
Meters.
on that and talk to
yeah,
Curtis.
phone a friend?
We're also, we have other areas in here for electronic sealing.
Oh,
So just using the term loosely as sealing is physical or electronic.
And that was Curtis Milk for the record.
okay.
Right, he uses metal. What's that? He uses metal.
Metal wire.
Difference.
Yeah, yeah, that's it.
Harder to make them look.
Yeah.
510, instead of trip sheets, we will have trip information. Paragraph 1, the administrator may ask for trip information at any time for good cause, striking the remainder.
I think LCD will want you to use request instead of ask.
Okay.
Do you need timing on this? Is there anything where you need that within a certain time period? Not getting it within a certain time period is a major problem.
Well, we have a statute for interference, and if
Okay.
I was to get it in a timely fashion,
Okay.
then we
I
just.
just
for it.
want to make sure you have a mechanism.
Yeah.
Karen, we're gonna go back to 510
No,
and add it.
no, going backwards.
You're gonna add it.
510,
I'd say with that 7 days.
are we in 10?
Say that again.
On 510.
510, yes.
Okay.
So the suggestion is going to be the administrator may ask for a trip information at any time for good cause, and it shall be provided within 10 days
Okay.
of request.
Ready to get that? 10-day rule.
$519, 1B, strike out valid for at least 2 years and add valid up to 2 years.
The reason for this change is people just aren't as healthy as they used to be. We have more medical issues that will create an issue for a medical card. Medical cards are good for 2 years, but we're seeing some doctors give 3 month, 6 month
Wow.
medical cards. Right now, we're not accepting anything under 12 months, but we can't, by changing this, that gives us that ability.
0.525.
On 706.525, we need to change the word to just permits because of what we just discussed, making it a 2-year permit. It's not an annual permit any longer. And so the verbiage would be to strike the word annual on the second line on 525.
Right.
On the second line, strike the
So
word
it's just
annual.
issue a permit.
A permit.
But you're looking to increase your revenue, right? Just keep it annual, collect twice the fee.
Again, we would strike the word annual on the third line, and for valid, strike 1 year up to 2 and add up to 2 years. And then number 2, strike the word annual, just make a permit.
And I think if they have needs to be stricken too, right? Are not renewable.
But then you're saying.
Actually, we talked about this yesterday, and I don't think I'm going to strike that portion of it.
The
So-
expired are not renewable.
You have to keep, well, that's one of the
Yeah.
triggers is that if it expired, you can't renew it because otherwise it's going to read permits if they have are not renewable. And I don't think that's
correct. Yeah.
Right.
what you need to say is if a permit has expired, it may not be renewed.
Right.
Something like that.
A permit that has expired may not be renewed.
Correct.
Yeah.
Yeah. Page 12, NAC 706.531. Strike the word bracket or and just keep it as holder. Page 13, 706.543, 4. We're going to move from 5 to 6 because some vehicles hold 6. Number 8,
Sorry, where you're at
543, yeah, and number 4, we went from 5 passengers to 6 passengers.
Is that on the copy that was issued? Because I don't.
Yeah.
Oh, I see. Gotcha. Okay. Right.
Got it?
Yep.
Number 8, not operate a taxi cab that does not have and strike properly affixed valid medallion or lease medallion and add digital or otherwise as issued by the administrator. Again, that's just in preparation for a digital medallion.
Well, now what you're saying is it may have a medallion but not display it, and that's still okay.
That's not what we want.
So you need to put display to account for the digital or leave the affixed. But now you're saying you can't operate a taxi cab unless you had a valid medallion of whatever type.
Right, it needs to be displayed
needs to be-
right
right.
now.
Yeah.
Okay. And we will strike number 11.
Is it? And we're striking that why?
Because the drivers are no longer keeping trip sheets. It's all done digitally within the meters.
For the industry.
Mhm.
So for the companies, so the companies want something in there though that requires them to. I mean, does industry rely on this to
require the driver
Require-
to do something.
Right.
Everything's digital on the screen. So
Okay.
you can see
Okay.
It's all digitally done.
Okay.
Page number 14, 706, 546.
I don't know
Because-
that you need to read it all. We're taking out independent contractor
Yeah.
everywhere because the definition of driver now includes independent contractor.
Correct.
And then subsection 3,
Subsection 3, we're striking the whole thing. NAC 706, 549. We're striking number 5. 706, 551, again, the independent contractor. We're striking after trip. We're striking an independent contractor and adding minimally twice per shift and striking the termination of each trip.
I have a pragmatic question about 551,
Okay.
which doesn't go to what you've changed, but when I read this, I went, In the line that begins with discovers any property of a passenger. Have you had any issues where the driver says, well, I don't know if that property was of the passenger?
No, that I'm aware of.
I just, it seemed to me should have been written, discovers any property that appears to have been abandoned.
Right.
Property that is not the driver's or the certificate holder.
Right. Or it could say any personal property.
Or any personal
Because
property, yeah.
regardless of who owns it, but yeah, it's a qualifier.
Yeah,
Yeah,
because
that's interesting.
this is theoretically is asking for a determination of ownership.
Right.
Right.
And I just see it as a loophole.
Any property in the taxi cab?
Well, I wouldn't say any property because the certificate holder has abandoned property or,
We could remove
discovers any property,
of a passenger.
Any person.
any personal property that appears to be abandoned in the taxi cab or something like that. I don't even use abandoned.
It's just
Any personal property,
In the taxi?
yeah.
Yeah.
Yeah, that's fine.
That one.
So why wouldn't you want the driver to search the vehicle at the end of the shift?
The language reads ends of each trip.
Oh, trip. Oh,
And
trip.
that's
I got you.
sometimes an
Yeah,
impossibility.
it wasn't a shift, it was
Yeah.
a trip.
Gotcha.
That's not happening. There's no way that's happening.
I got you. Right.
NAC 706, 552, strike independent contractor. Under 2A, add except an independent contractor. Change the big U to a small u on. Under 2B, add after driver's permit or the parent company thereof. 706, 555, strike independent contractor. 706, 5551, strike agreement on 1A and add template. Page 17, same statute or same NAC on letter C, strike agreement and add the word template. And then after the word medallion on that same line, add or a digital medallion and strike all of number 2.
You no longer need to know.
On the template,
On number 2, if lease agreement executed terminates before the expiration date, you will be notified. So if it terminates early, do you not need to know that?
I think we would know that, wouldn't we?
We wouldn't know until we got-
In our meetings, it was determined that you know, we've got possession of the cab, so you guys don't really need to know.
For the record,
It just serves no purpose.
It's information you're gonna have to do what with.
Right, I don't know. I mean, that's why I asked.
Personnel for the
Originally,
record.
it was put in there because they were afraid.
We
that
haven't been
wouldn't have a
capturing
car.
that data.
Okay,
haven't been captured.
Well, everything's explored.
Page 18, 706, 5557. 1, subsection 4, Roman numeral 2. Change from, strike the word day and replace it with the word week. Page number 19, 706, 5559. I believe this is the one that Desiree wants to discuss. We struck number 2. And on number 3, we are striking on the second line, any interest accrued by the security deposit. And then on the next line, strike if the cost of the repairs exceed the amount to the end of that sentence.
what's the purpose of striking those? So it's basically, number 2 is saying that it has to be a trust account.
Mhm.
That sounds fine. So what, maybe this is a request of industry and they'll talk about it, but if Curtis was ever auditing books and there was a problem, I don't know. I don't know if that has ever been an issue. But then the other one, you're striking out that striking out their authority to retain the deposit in the event that the cab's damaged. I mean, do we have a purpose for that? Or is that something that the industry is requesting?
I think,
The interest part, we were,
Yeah, we, having the.
Why don't you come up to the-
security deposit in a separate, sorry?
On this one, let's come up to the table because this is also Desiree's additional
Desiree, you can handle all that.
comment.
Desiree Dante on behalf of Lucky Western and Ellis Cab. We were striking the part of paying interest on the security account.
Mhm.
That is the part that we wanted eliminated. And the part that I wanted, or we had requested during the workshop in section 3, regarding the security department or security deposit minus the cost of repairs or money owed to the certificate holder. Because sometimes they leave and there's other things other than costly repairs that are owed to us. So that was one thing we wanted to add, minus the cost of repairs or money owed to the certificate holder.
Minus the cost of repairs made to the taxi cab.
So, right. So basically, the first part you're saying we're not going to owe you interest, which I don't see a problem with that. But the second part, if the cost of repairs exceeds the amount of security deposit, do you have authority in law elsewhere to keep the entire security deposit, or do you need it, or is that
Yeah,
important?
So first of all, I think that your new we'll get there. Your new language is in the wrong place, Desiree, because it doesn't need to say minus the cost of repairs made to the taxi cab pursuant to subsection 4 or monies owed to the certificate holder.
Well, right now, they only allow us to keep the security deposit if there's physically repairs that need to be made.
No. I'm giving you or monies owed. I think it is in the wrong location in your language. I think it belongs after repairs made to the cab.
Or monies owed to the certificate holder.
After
Yeah.
yeah.
That's fine. We just wanted to get in there.
Do you get what I'm
Yes.
saying? Okay, yeah. Now, to your point,
So do you guys use a trust account right now for security deposit? No, you just throw it into an operating account?
Right now,
Okay.
we keep it separate
Okay.
because we're required to keep it in a separate account.
But you don't want to, you don't see a need for it. And if the agency doesn't see a need for it, and you agree, fine. Of course, that's not how your industry works, but.
no, but I don't see a problem with this. I see this as a business transaction with the lessee, and I'm not sure why we got involved in trying to regulate this in the first instance. I do get wanting to be able to say, if you banged up the thing, you don't, what's the reason why you don't get your security deposit back? But where they put the money, I'm not sure much matters to us. They're going to have to, if the driver, if the lessee is entitled to the money and they don't have the money in the bank account, they're going to have to go borrow the money or,
Doesn't matter.
take a roll of the dice at the table and hope they win or whatever, so.
But the second part, the cost of repairs exceeding the amount of security deposit, I would think that
Say again?
the second part, under 3, which is the legal authority to keep the security deposit, saying if the cost of repairs exceeds the amount of the security deposit, the certificate holder may retain
It was allowing us to retain the interest.
interest.
Interest accrued.
Okay.
Yeah,
There's
I-
never,
And we're not gonna put it in an interest-bearing account.
So it doesn't matter.
Right.
Okay.
Yeah,
Okay.
I think 3 otherwise allows them to keep the
Keep
deposit.
interest. Okay.
it was just that really pertaining to that interest
Interest.
accrued.
Yeah,
Gotcha.
right.
Okay. Good. Thank you.
Yeah, and the interest isn't likely to make you whole anyway.
So can I read it back just to make sure we want to? Okay. Oh, sure, Loma Web.
Sure.
I'm going to read it back.
And we're in subsection 3, right?
We're in subsection 3. Upon the termination or expiration of the lease agreement, the certificate holder shall reimburse the independent contractor the amount of the security deposit minus the cost of repairs made to the taxi cab pursuant to subsection 4,
If any,
if any, or money owed to the certificate.
or monies owed to the certificate.
Right. Thank you.
Could be that they didn't turn in their ball cap or whatever.
Yes, thank.
Yeah, right, empty gas tank.
5563, removing trip sheets and calling it trip information. Submit a daily trip information, so I guess we would need to remove the word A, submit daily trip information. Sound accurate?
So you're in which section?
That was 5563.
Yeah.
Okay. 5565, lease medallions. Strike 3A.
And insert or is digitally restored, right? Stored in 1.
Oh, yeah, and add or is digitally stored. Thank you, I didn't see that.
So what's the effect of getting rid of 3A? Does that basically mean,
There's a statute that allows us to lease them all. If we got that removed,
so?
We're not abiding by this.
Record of George Bell, then what?
we're not abiding by this currently.
Right, you're leasing as many cabs as you want to, regardless of medallions, right?
Well, that's what, we're kind of
we
curious
can't
how that's being interpreted.
We can't.
Not that we have a
accept the
position on
Wait a
it.
minute, you're both talking, one at a time.
Yeah, please
And
identify.
name who's talking.
Michael Bell, Taxi Management. We're curious what the interpretation of that is right now.
Well, if we're
Because
getting rid of it,
obviously-
we don't much care about it. Oh, what you're saying is if we keep it, what?
I mean, it says 50%, but that doesn't seem like anybody's
Yeah.
stand to that, or there's no enforcement on that. And we don't have a position on it, but we're curious on what your interpretation of that is.
Is there a reason, JD Decker for the record, is there a reason to limit the number of lease cabs at this point in time? I mean, there may
Yeah.
have been in 1970, whatever, but
Todd Park, for the record, I can't put the toothpaste back in the tube, that this is something that's been going on, and that's why I thought I'd just get rid of it. And I don't see any good reason to continue to keep the 50%.
Cheryl Gibbons, if I may, this language was put in here without industry comment when the lease regulations were first approved.
Right.
And once companies started leasing more than half of their available medallions to try to get vehicles on the road, they realized that this regulation, it was not being enforced, it was not enforceable if we wanted to continue to grow the industry. We can never lease or have as employees more cabs than we have medallions, but we can have an entire cab company be all lease and not 50% employee and 50% lease.
Correct. So that's how I read this.
Yeah.
Right? We're not going to try to regulate whether they're a totally leased company or not a totally leased company.
That's my point, is that I don't see a reason to limit the number of
Yeah.
leased cabs, and
Right.
I was asking the administrator.
So I just wanted the record to reflect why we're, if down the road somebody goes, why did you do that?
And then also in 5565, paragraph 4, add affixed to taxi cab and add or be digitally available in a taxi cab.
We can jump to page 27.
Seven oh six 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 nine. Paragraph 3, deleted 100 and changed it to 5,000. Apparently, the industry thought that was a bit,
Thank you.
there's a lot of work to that.
Cheryl uses a pen that costs more than $100.
And corresponding with that, and Mr. Galvin had brought this to our attention. 706, 720. At the end of paragraph 1, also needs to be 5,000. We did not have that in your copy. We need to change the last part of 706, 720
Sub 1.
of 1, 5,000.
We can jump to page 64.
All right.
Yeah, now we're moving.
Now we're moving.
As long as we're here, Curtis,
Here's where,
706.
before his page, 706, 795 regarding account for fees.
795?
795, yeah. I'm thinking maybe the industry wanted something on that we didn't, that we,
706.
page 37, about fees payable. I just don't remember what the industry wanted on that one, and I did not write it on. Is that about the tech fees?
Yeah, Mike Malloy, ACAB for the record. That was because currently we're currently reporting the 25-cent drop that we pay to you guys every single week as revenue on the monthly reports. And then when we have to do the accounting at the end of the year and turn that in for the annual report, we're not allowed to report that as, we have to report that as an expense, but we also report it as revenue. It can't be both. So there needs to be some clarification as to either not reporting that as part of the revenue per month or vice versa.
Isn't this saying, trying to resolve that problem? Oh, no, it's referring to.
Is there another regulation that says it has to be on your, or are you just from, using GAAP you're reporting it, because you're holding the revenue for a certain period of time?
Correct. Well, it will payable monthly to the tax cap authority as well. I think it is,
For the record, Curtis Mel, it's on page 41, 813.
8-1.
It's 795 and 813 conflict with each other.
Would it be fixed, Curtis, if 706-813 began before 1, 2, and 3 says except as provided in 706-795? In other words,
I think so. So instead of being a liability, I'm sorry, Michael Gray cab, except as a liability, it would be an expense as referred to in 795.
Right.
Okay, then that would,
Yeah, 795 would control and the 813 inconsistency would be eliminated.
or we could line item out the 25 cents on the receipt.
Right.
Just pull it out of the fares portion.
And subject to gap, I'm not a CPA, so I don't know if your CPA will let you do that. So Lonnie, you may want to note that change to talk to LCB about, because we want to make sure they understand why the intent of that is to stop an accounting entry.
And just be clear, we're not sending it to LCB right now because it's going to be temporary changes. And-
Oh, that's right, yeah.
And then
But
we'll.
down the
send
road,
LCB
LCB is going to ask.
And the final change would be.
Final change what, in what?
Deleting, if you go to
In what
paragraph,
section?
if you go to paragraph 64, or page 64.
Okay, so we've been bouncing around. We didn't
Yeah.
really get to 64 yet.
No, and we want to
Okay.
delete NEC 706991 through 9918.
Can you make my heart pitter patter for this?
Lona is
For the record,
ensured-
the legislature repealed the statute upon which this was
Oh, that's,
based, so.
and Lona is securing her job security over there.
Okay, with that, do members of the industry have anything they want to, wasn't trying to cut you out, but is there anything more you want us to consider, or?
Do you want me to step up, or do I?
Yes, please do, and put it on the record so we can create the kind of document that they all see, or that somebody's going to require us to have. So.
Rich Fritz, Desert Cab, Virgin Valley. When they had the aerial, and they put the aerial helicopter numbers on there, they also there's a green distress light that's on top of all the cabs. So there's a button that you push on the floor on the left that turns the green light on and it flashes. Nobody knows what the green light's for, except for my dispatcher, because it actually sends them a signal, which we would keep that light in there. It sends them a signal that the driver hit the button. So they would call the driver and make sure he's okay, monitor his location, do all that stuff. But to have the green light on the car is just, again, the police don't know what it's about. So it's just on there and they fall off and the TA redlines the car. The guy has to come back to the yard to fix the light, do all that stuff. So it
I
actually
actually
is.
saw a driver yesterday in the queue at the airport hitting his because it was not illuminated.
Yeah. Right.
It did turn on after, so he knew how to fix it. So
The green light or the amber light?
the amber light.
Yeah, so two different lights.
Two
So
different lights, but
One's
yeah,
a cheater light, one's an amber, yeah. So the
Is there-
distress light is the one we're
but
talking
is,
about.
but two-way communication allows him to say, I'm in distress, right?
Correct,
Yeah.
correct.
I would just throw out, I'm not sure law enforcement doesn't know about it. And I don't know if I know about it because I'm law enforcement or because I've been in the transportation industry. So I don't know where my knowledge came from, but I do know that there are times when criminals take cabs. And I can think of a specific incident where the cab that criminal was escaping in got stuck in a traffic jam on the strip. And law enforcement was on foot trying to figure out which cab
Oh,
the
yeah.
suspect was in. And the light
Green line comes
can
on.
help. It makes a huge difference. I don't know if that's I mean, if that's a thing that Metro doesn't care about, then I would say I don't care about it either. But I'm not, are you sure that it's not used by law enforcement at all?
I have the lights on all the time and one of my cab drivers has never been pulled over and said, hey, your green light's on, nothing like that has ever happened.
Okay.
So I've been in the cab business for 39 years. So-
Just anecdotally, only because I draft for ordinances for some local governments in the north, they are still requiring, they've done away with the numbers on the top of the cabs. They're still requiring, some of the county and city codes in the north are still requiring an emergency light. And that may be because RPD or Winnemucca PD or whatever pays attention to it.
All right. Well, this was on the same board order that the lights were on, so it was the same. So it's not an AMC.
Correct. And so we'd have to do something to put it in, right? And so what you're basically saying is, hey, by the way, when you do away with the number on the top by ignoring that order that nobody can find,
Correct.
we're also ignoring the green light and it will go away, and you're letting us know that. And you don't have a problem with that.
I don't have a problem with that. I'll notify my inspector.
And if you did have a problem with it, there's really nothing that
There's
you
not
could
a
do
lot I
anyway.
can do.
Well, right, today, you'd have to ask us to adopt it. Okay. I like,
Thank you.
yeah, that's great. I love doing away with things that don't have, are not part of the rule of law. Go ahead.
So for the record, Kimberly Maxon Russian, on behalf of the Livery Operators Association. Member Decker's point starts on page 5 with respect to the color scheme and goes to page 6. Agreed that there needs to be a distinction between the carriers. I don't know if we need to necessarily have the language certificate holder, because we recognize the fact that certificate holders under that umbrella, but perhaps it's better if we seek a deviation in that. But I think it's important to maintain the distinction between the carriers and the vehicles that they're operating. So just wanted to say thank you for that. That was one that we were going to bring up.
So before we move on, so you're saying that in NAC 487, we do need to capture some language that requires distinction.
Yes, sir.
Yeah.
We could use the term carrier, Chairman, because of the fact that that would
Correct.
give the,
But we can use the noun taxi cab.
yes, sir.
Right, but each taxi cab in separate ownership
Yes, sir.
or something like that. Go ahead, Curtis.
For the record, Curtis Mel, just for clarification, 487 is for temporary modification.
Oh, yeah,
Color
it is.
schemes. 486 is for color schemes and insignias.
Okay.
We want to have the distinction.
In 486.
486, but the 487 is just for wraps. Really, that
Got it.
regulation came into place for temporary modifications. If we want to have language, but it's not for permanent insignias and color schemes. 486 is the permanent one.
Well, JD Decker for the record, I get that, but if I wanted to look like a desert cab, it'd be much easier for me to get a wrap than to actually paint my car. And if I wanted to show up to a taxi stand and have trick people into thinking that I was legitimate.
For the record, Curtis Mel, I get it, but they still have to be approved by the administrator. We do currently have wraps out there like Planet 13 that, or I don't know if they're still out there, but they've been out there and they go across.
Every
cab company.
Oh, okay.
And they all look the same, but they still have their company name somewhere on the vehicle.
And our
Unit
cab
number.
number.
So, okay, so temporary modification would more likely be some kind of advertising than
Yes, the wraps.
a brand. I get you. Okay,
But
I get it.
I'm not sure I'm not sure that we probably need a different kind of regulation because we have a statute that says 8833. It says the color scheme and insignia of, this was the struggle we were having before. There was a statute that we were facing. This color scheme and insignia of taxi cabs of each certificate holder must be readily distinguishable from the color schemes and insignia of other certificate holders.
The insignia being the company's name and the identified number of that vehicle.
Right,
That would be the difference.
right. And I think you're correct, Cheryl, for the record. We previously ruled that if the insignia, it was an and, that's how we interpreted it. So it's white, all cabs could be white, and the insignia would be the only distinction. Or a group of companies could have all cream colored, or not cream colored, green, and the insignia would be the only difference. So
Chair, to your point, and again, consistent with what obviously staff was thinking about and knowledgeable that the wraps are often utilized amongst different carriers and they're the same. Then we should likely go back and maintain the amendment as proposed by staff to repeal that language because that would allow them to utilize the same wraps. But we're making the record clear relative to the difference between temporary versus
permanent.
permanent. Yes, sir. Okay, thank you. That helps.
So-
Thank you,
so-
Curtis.
Are we good, given the interpretation we have given to 8833 of the statute? And it's just the temporary regulation we need to futz with?
Yes, sir.
Okay. Got that?
Yes.
Make sense?
So we're good on 486 and good on 487. That,
Yes, I think we're good on 46 and 47 because I think we've given a statutory interpretation. Now we're really making it clear that we've given that statutory
And
interpretation.
theoretically, it's about advertising, not the company
That's
logos.
correct.
Yeah, so
That's right.
if CA wanted to advertise.
It's not branding. It's
Right.
not branding, it's advertising.
That's right.
Right.
Okay.
So that company A, certificate holder A could come in and say, that insignia looks exactly like our insignia and we're all white cars. So it's a branding issue. Logos and all of that business, yeah.
But MGM could say, I want to put our logo, I want to put a temporary wrap on every cab in town,
That's
regardless of
right.
the
You could
carrier.
do it.
Okay.
Yeah.
Okay. Right. Got it.
If he allowed it,
Right.
he being the administrator. Okay.
thank you.
Question, go
For
ahead.
the record, Kimberly Maxim Rushton with respect to the Livery Operators Association. Chair, if I may fast forward to page 52.
52.
Yes, sir, under the classifications of the parties.
I will date myself. Is that the fabulous 52? Date and show what, where I grew up, right? Those who didn't grow up in LA, that was a television show.
So one of the things I wanted to raise is the fact that generally we have parties that are defined also under the Administrative Procedures Act 233B. But there's not a distinction between a party and an interested party. So I'm thinking that maybe we could consider using the statutory definition of 233B 035 as a party. And I think it captures what the intent is here. And if I may just read that into the record, Chair, because I think it helps clarify.
So before you do that, my interpretation of interested party using PUC is that they had the same problem and they just called them commenters.
Or protestants is
Or
what we use over at
protestants,
the NTA.
yeah.
Yes, sir.
But limits their participation to submission of some writing.
Right. But it doesn't categorize them as a party in the ability to then take action post-approval or action of the administrator, meaning that they could not take it up on a
I
petition
get
for
it.
judicial.
So you're
review.
striking interested party, putting the or to intervener, right? Is that what you were?
So.
Well, go ahead. I won't interrupt you.
No, sorry, I was just thinking, I mean, again, we can leave it as is with respect to the intervener and then just modify subsection E to just say a protestant is a person or persons who have an interest but do not satisfy the intervener. Or you could specifically state that classification of parties, a party is consistent with the definition as set forth in 233B 035, which is any person or agency named or admitted as a party or properly seeking and entitled as a right to be admitted as a party. That gets you a little bit of a hiccup, and I'll just tell you, because what happens is
I
that
agree.
you have a protestant that comes in, articulates a point, and then under the NTA's authority, they can then ask to be admitted as an intervener because they demonstrated to you after the fact. So perhaps they didn't see the issue ahead of time, but they wanted to comment on it. Now they've articulated a position that's equivalent to that of an intervener, and it would give the authority or the ability to now recognize them as such. That's one way. Otherwise, you could just fall back to the easy definition, statutory definition as a party is this person and go from there.
So for those of you that are, this is inside baseball, I apologize. So my druthers would be in subsection 1 to strike the term or interested party, insert an or, take out the comma after respondent and insert the word or. So it'd be parties to a proceeding are an applicant, a complainant, a respondent, or an intervener.
You have to strike sub E also.
Huh?
The sub E is the definition of an interested party.
No, and then I get that. Then you would take subsection E and turn it into 2 and have a provision that says the authority may allow an interested person to participate as a protestant or commentor whose participation will be limited to submitting written comments.
With a reference to 233B.
I don't even think we
No.
need to refer to 233B because I think we then, to Ms. Rushton's point, there is this wrinkle in 233B that lets people get intervention after the fact, and people do it. Instead of filing, they comment and comment and comment, and then they show up the day of the hearing and put something on record, and they now have triggered intervener status, and they make a motion to get in. And they haven't had to do discovery, they haven't, is that the problem you're talking about, right?
And if I may, for the record, Kimberly Maximus, defer to my colleague Cheryl on this, but historically, when individuals, members of the industry wanted to participate in a matter, we would sign in as a
Yeah.
PLTI. Obviously, we've gone back to the more formal process and everything, but I would hesitate to limit people to just the submission of written comments because there may be something that they just didn't understand, pursuant to the initial filing. But once the matter starts getting fleshed out in a hearing, they may want to come up and ask a question or be recognized as a commenter or a protestant. So maybe we just leave the language as is and don't qualify it by saying that they have to do a written submission.
So I think we can go to the PUC regulations and basically copy this.
I have that. Yes, sir. What I could do is the NTA has mimicked that as well.
Yeah.
And it allows for both written and verbal and gives the qualifiers.
Yeah.
If I could participate or draft that in conjunction with Ms. Webb, I'd be happy to. I mean, recognizing what our intent is here.
And then I'm glad you're bringing this up because all these procedural regulations drive me nuts right now. We don't, if I understand it, we do not allow late petitions for leave to intervene. And so I would suggest we, in conjunction with this, copy that language from the PUC. And the reason for that is the very inside baseball we're talking about. Sometimes that person does show up and they have a very material interest. And then there's no mechanism for them to be recognized and participate, even though you're irritated that they're participating. And then they have now created a judicial review issue that has to be shoved into the courts. And the agency doesn't have a way to protect itself from the judicial review. So I'd kind of like to, if we're going to futz in this area, I'd like to futz all the way.
Yes, sir. And so for purposes of the record, under the MTA's regulations, there's a whole regulatory scheme which talks about untimely
Right.
PLTIs and when those will be considered, what the standard is for that,
Correct.
and then the discretion that the board has to allow it. And it's very well laid out. And I also think there's some other things like answers to in timeframes that we could also utilize that would just strengthen the regulatory practice.
Good with that.
And JD, for the record, I'm reminded of the Sunset Subcommittee order, which was to combine the regulations and make them consistent, so.
Yes, sir.
Yeah.
I think that'd be a good idea.
So as a take back, Administrator and Ms. Webb, maybe go through the MTA and the PUC's procedural rules and see where you might grab hold of some of these, because this is a issue waiting to happen. We did struggle in the independent cab case. We struggled with some of this stuff And it was in part why it took a year and a half to get it to hearing. Because everybody was making all of these procedural arguments to the hearing officer, right?
And in that time period, you could have had a new operator, such as what you have now,
That's right.
that would have not been, had the large use of, understanding really what the intent was or wasn't around during that period, but may want to express an interest in intervening, and that would be an untimely. But there's a really good
Yeah.
statutory scheme that was taken from the PUC that I think, if it's okay, I'll work with Ms. Webb on this afternoon.
And the administrator reminds me, we may be able to do this in a very efficient way by saying we adopt the following provisions from the NTA, because we do have that
Yes, sir.
rule that we could do. So you might be able to just do that efficiently.
Yeah.
That then, if I could just respectfully move to page 54 under pleadings, motions, and other papers. That's along the similar lines, Chair and Member Decker. With respect to the pleadings, that's fine. We can leave it as is, or we can also go further to talk about what I expressed earlier. If it's a pending matter, you have a motion. That doesn't require any additional fee. If it's a protest, or a petition, that's something that you're asking for from the authority. That would be a filing fee. There's a filing fee at the NTA, things such as that petition for interim authority. Maybe we could tighten that language up relative to
Are you
pleadings.
talking about 903?
900 actually.
900.
sorry,
Okay,
just
900,
pleadings,
okay.
sir.
You're talking about adding a fee to 900?
Well, with 900, what we could do is we could restructure this to show a differentiation between what a motion is and
Yeah,
a
yeah.
petition, and then assign a fee to the petition because
Right.
of the fact that it's equivalent to an application. So that's what I'm thinking in that
Or
regard.
triple it?
Yes, sir.
I would allow the administrator time to fill that out because that could put the entire reg file at risk if
There's a new fee.
If
Put
there-
the entire,
this entire reg file
oh,
at risk if there is not an appetite for a fee through the
Oh.
governor's office or LegCom.
good point.
So, and to that point, Member
Because
Decker,
it's a temporary, right?
Mhm.
Yeah.
that's where we go to 903. What we could do is amend that language to just say all applications generally have a $400 filing fee.
Well, I think Member Decker's point is that LCB will say, or somebody could say, LCB wouldn't be doing it. Somebody could challenge the temporary regulation and is having adopted fees and you can't adopt new fees. But we can, when this comes back as a permanent,
Okay.
put in fees.
May I make a comment on that?
Yeah.
With respect to the timing of our temporary, which will expire November 1, and
Yeah.
The permanent, I've been told by LCB that if they mirror each other, the temp and the
They
permanent,
just sail through.
it'll go through. But if we
Futz with it.
change anything, it could be
Correct.
a long time.
Right.
So because we need it to fly through fast, I just
Right.
want to throw that out there, that I'm not sure.
Well, it might be beneficial to have a temporary reg kicked back for a fee than your permanent reg file, which you do in November, before November. So it might be a way to feel it out. I don't know.
Perhaps just consideration of 903, amending that just to say that all applications will have a
Yes.
non-refundable filing fee of $400. And then we'll mirror that up in each of the respective, such as 906, which has the non-refundable fee, will increase that to 400. Same thing, Chair, with respect to page 55, this is an application for changes of rates or rules. I would include a filing fee in there with that, or if we just capture it under 903, it's automatically applicable, so. Just trying to help you get some money.
Thank you.
Yes, sir. Okay.
You kind of lessen what you have to get out of the legislature here.
Well, I think every bit counts.
Yeah,
so.
I do.
I now direct your attention to page 59, the presentation of evidence. I will submit in advance, and this is going to sound very random, but it works. This was the order under subsection 2 about how evidence will be received. That was the way that the NTA previously had it. The intervener went last, and then there was rebuttal by the applicant. What happens in that instance is staff is really there to give you an objective position. So the intervener goes last. Staff oftentimes may change their position based on what the intervener presented. So at the NTA, they modify that subsection 2 and 3 and switch those. So it goes applicant, intervener, authority, staff, and then rebuttal. It seems to work better because it gives, I think, the board, understanding or better understanding that the staff has considered the intervener's position and is now ready to opine on that.
So I have no difficulty with that, but this is an ordinarily will be received, and I will just, remember Decker was there in the independent cab. I let staff go last every time. For that very reason. I want the parties to weigh in and then staff at the end. But we could true this up to that.
The only other change I have
The
with.
only other?
Yes, sir. And then happy to answer any questions that you may have. Is on page 61, and this is just at the top with respect to 706.951, mirroring how we just addressed the interested parties. So we just shore that up.
Parties?
Yes, sir. The language that we have previously discussed.
This one and the last one, are there, you said there are NTA regs?
Yeah.
Well, anytime we can match the NTA reg
We can do it.
is great. I mean,
We can do by a regulation that simply says we adopt the following NTA regs.
gotcha. I mean,
Procedural regulations.
right.
And
Because
that may be way you do this on the fly.
So anything helpful? So thank you.
Yeah, no.
The interesting, the repeal of the section pertaining to the appeal to the NTA, that happened in 2015, the statutory language changed. We immediately went to LCB and said, you need to modify the regulation, and they said, no, the agency needs to do it.
Right, right.
And of course, we argue with them about the cost associated with it, but they said, nope, the agency has to do it. So glad we can take care of it all at once.
The only thing we need to be thoughtful about in the adoption by reference is we've got to say, and those replace the following NACs. So that there's not a confusion that the existing NAC in our NACs applies alongside the adopted one.
well, since we have since the reg file is open or gonna be open, wouldn't it just be easier to actually replace our NACs?
Yeah, it would be. So we could just go through and wholesale put the NTAs in if we wanted, or.
I mean, I'm gonna tell you, from my perspective, from only seeing, there's enough confusion in 706 about what applies to NTA and what applies to TA.
Oh, yeah,
It's very nice to not have to reference and to just have.
the same procedural rule.
Yes.
Right. Yeah, and they have recently, I mean, theirs are much more current than ours, and they go back and massage theirs all the time, it seems like.
So I'll work with Ms. Webb on this and get this out timely.
But thank you. Any other, yes, Curtis?
For the record, Curtis Mel, just so you're aware, under NRS 706-8818, we do have a provision that reads, except to the extent of any inconsistency within the provision of 706-881-885, every regulation and order issued by the Nevada Transportation Authority remains effective in a county in which those sections apply until modified or rescinded by the taxi cab authority. They must be enforced by the taxi cab authority.
And I'm aware of that section. I think, Curtis, that section was to make clear that until this body did something differently, that it didn't wholesale repeal lots of stuff. I'm not sure that section allows us to say, well, this time we're going to follow this procedural regulation. I think we have to be clear about which procedural regulation is going to.
I was just hoping it would save a little work.
Yeah. Okay. Sure.
Cheryl Gibbons for WHC. Earlier, we had talked about a driver's license and the fact that it's illegal to not drive without your driver's license on you. There's one that I'd like you to take a look at removing, and it's NAC 706-546. It's conditions of employment, and it states that no certificate holder may allow a driver or independent contractor to operate a taxi cab under the following conditions. When the driver's license of the taxi cab driver is not in his or her possession or has been suspended or revoked by the DMV until proof of reinstatement of driving privileges has been furnished to the administrator. It's illegal for anyone to operate a vehicle in Nevada without a valid driver's license. And currently, the companies are forced to have the driver, when he starts a shift, show us his driver's license. And then we've been dinged by audits in the past where drivers have received a citation for not having their driver's license on them. And it's like, yes, we do check it when they come in, but that doesn't stop them from going home for lunch,
Right.
leaving their wallet on the counter, and then the driver, him issuing a citation is fine. We just don't think we should have to be responsible for that.
Point taken. What I would say is, what I would put in here is, no certificate holder may knowingly allow a driver. I would add knowingly, because I think the idea is, there's no way for you to know unless you check minute by minute whether someone's driver's license has been suspended.
Correct.
But there's conceivably confusion between the carrier issued me a permit, therefore I don't need a driver's license, or therefore I can continue to drive without one. So I think the idea is you shouldn't be on the hook for what someone does unless you know about it and you're still letting them. And so I think if you
I
add,
like knowingly.
yeah.
Well, and these are conditions of employment, so it's, could be at the time of employment, determined that they have a driver's license.
Right.
Right. And leave, as Cheryl points out, the general law that don't get in the car without it.
But it's
problem
only,
with that is number one, because it says we may not allow a driver to operate a taxi cab under any of the following conditions. So that's perpetuity in perpetuity. It isn't just at the time that we hire them and onboard them.
right, and the intent of the code is only as good as its application. If you've been gigged using this, then the fact that we read it to say, hey, at the time of application for employment.
No, we would have to change the language as to the license.
Right, okay.
Good point, because the child support licenses get suspended.
Right.
If you look at the license, the TA costs come get the car.
Any other comments on the big packet? Okay. I'm going to talk about my little packet. So I'm making, I would like to suggest we make changes in 4 sections, or have a additional 4 sections. The first one, section 2, is to eliminate the entire uniform system of accounts from the regulations. And in its place, cause there to be a manual that is adopted pursuant to a scheme which is allowed for many other agencies by the administrator that allows, at least initially, we would move all of them in. But then you can go through them and clean them up. And you don't have to go back to LCD. NDOT uses this. The Commissioner of Financial Institutions uses this. NDEP uses this, where they create these manuals. The manual goes through a process. Amendments to the manual go through a process. But you do not need to codify in a cumbersome to change manner your uniform accounts. I don't know that anybody will disagree with this. The current regulations on uniform accounts read exactly like they were made in 1975. They don't take into account modern or current GAAP or other accounting standards. And so I think we need to move toward a less cumbersome process that allows this to be done on a faster track than waiting a year or 2 for a rulemaking to go through. So that's the purpose of subsection 2. Subsection 3, and the process there for the record It's copied from a regulation I wrote for NDOT in 1986. So that still exists today on when you can get encroachments on public property. Subsection 3 is to address the fact that we kind of have a procedural hole in our regulations. It does, and this, we've just made it up as we've gone along, and we need to not be making it up as we go along. There's not a procedure by how we select a chairman or vice chairman. There are no comparable regulations designating the chairman to act as a presiding officer, to make evidentiary rulings or enter orders, or to appoint the administrator to do that, or to have hearing officers appointed. They're talked about, but there's not a rule that says how you go about doing it. As we recently experienced, there's not a rule that explains what we did in independent cab and what we're doing in the other docket that's pending, how we move something to the administrator to get a hearing officer in place. There was a potential issue in independent cab. The statute of limitations is run, so I don't mind talking about it, which was, could there have been an appeal from the denial of the certificate because there was no procedure that set up how you appointed and what a hearing officer could do. So the purpose of 3 is to address that. The purpose of 4 is to address an issue we just recently had on what happens when you have a rehearing application and it's a emergency type of situation. Do you have to conduct a public meeting, or can the authority, the presiding officer or the administrator for good cause enter some kind of a stay of an order? As the administrator and I have spoken, we must have some kind of a safety valve in the regulations for the aha moment. We just created a problem nobody brought to our attention, and it could have a catastrophic effect. And we don't have any, we don't have a procedure in place for that. So that's what subsections 4 is on. So those are some thoughts, and be happy to take any comments on these at this point. I know you're seeing them for the first time. Okay. So are there any other items to come before the workshop at this point? Administrator?
I have none.
Ms. Webb? Anything from our DAG? Anybody of the members of the industry present? I see there's some people that are hanging on remotely. Is there anybody remotely that wants to make any comment? No, we don't see anything. Then my suggestion is that this get referred back to staff to get another draft pulled together. And with the assistance of the AG's office, if we need to do another workshop, I know there's a kind of a standard as to how much we've changed, and if we have to come back and so on, and you'll have to review with the AG's office whether we have to hold another one of these. And the timing between that and when we could do an actual adoption, I think it might be able to be very closely timed. So, anything else for the good of the order? If not, I will call this workshop adjourned.
Thank you.